जिसका 117 में है they will stay.
Those who have presentation in room number 315, please go to that room. That is in the
Madam.
Second floor, please.
Thank you, sir.
Third floor.
अब क्या नहीं है क्या?
So these are the participants who are participating in technical session 1, paddle session 1. Now I am announcing the participants, those who are participating in technical session 1, paddle session 2. Isha Das, BLLB student, Uttarayan College of Law. Ananya Sarkar, BLLB student, IILS, Kuch Bihar.
Momento.
I hope you all are present over here. Please wait few minutes for our chairperson. IILS. This is another request to all the participants. Those who are presenting their duty over here, they are requested to please transcription will be filed in this laptop before starting this.
এটা তো ম্যাডাম দেখো যদি পাসওয়ার্ড ছাড়াও কোনো লগইন পাসওয়ার্ড নরমাল তাহলে দেখে নিও উপরে যাচ্ছে সেটা এটা লাইন আমার উপরে প্রেজেন্টেশন আছে আর হয়ে গেছে पासवर्ड पाओ जाएगा पासवर्ड हाँ हाँ
लैपटॉप में पासवर्ड अच्छा ना इंटरनेट इंटरनेट আমি করে দিচ্ছি
কে জানো হোয়াটসঅ্যাপে দিবেন
হ্যালো
হ্যাঁ
হ্যালো হ্যাঁ বললাম
ইমেল করতে পারবেন ইমেল যেখানে অ্যাবস্ট্রাক্ট জমা করেছে সেখানে মেইল করেছে আপনার
পিপিটি শুরু করে করবে এটা পিপিটিটা হ্যাঁ আগে দাও যা করতে हाँ जैसे वहाँ पे Please pay attention and reading the participants once again. For the technical session 1, parallel session. Dr. Melissa Shah, Assistant Professor of Law, Department of Law, University of Scotland. Dr. Rakesh Mandal, Assistant Professor of Scotland. Shreshi Madhagar, Assistant Professor of Sociology, Charan College of Law. Shrinkal Das, Assistant Professor of Charan College of Law. Rohan Mukherjee, Assistant Professor of Law. Kuleshwar Datta College, University of Kolkata. Ms. Jyoti Dash, Assistant Professor of Law, IILS, India. Dr. Shankar Chakraborty, State Aided College Teacher in Law, Jalpaiguri Law College. Repeating the participants' name for the technical session, session 1, Dr. Shobhatu Talukdar, Assistant Professor of Law, Government Center of Legal Education, University of Bardhaman. Ms. Sushmita Haldar, Assistant Professor of Law, WBES, Government Center of Legal Education, sorry. Dr. Sneha Singh, Associate Professor, School of Law and Justice, Admas University. Now, first of all, I am welcoming our Chairperson, Professor Dr. Parthapatim Paul, Assam University, Shishwar. And after his presence, I am again formally welcoming you all after the lunch break. Yes, we are ready for the technical session 1, panel session 1. Myself, Aditi Sharma, your coordinator, and we are having two rapporteurs, Ananya Sharma and Archita Chakraborty. Before we begin, let me briefly outline the rules of this session. The theme of today's technical session is globalization and human rights, challenges and opportunities in the connected world. Each presenter will have 5 minutes for their presentation, followed by 2 minutes for questions and discussion if required. I request all the participants to kindly keep within the time limit so that every participant get a fair opportunity. It is my humble request to please keep your mobile phone in silent mode. Now I invite our first speaker on the podium
With the permission of
with the permission of our chairperson, Professor Dr. Parthapatim.
Can you just my piece of paper just my
First speaker,
Hello? Hello?
Second, we start.
Sure.
Now I invite our first speaker of the podium. Our first presenter is Dr. Rakesh Mandal, Assistant Professor of Law, University of Bardhaman. He is head of the Department of Law, University of Bardhaman. Sir, please. We have not
Very good afternoon to everyone and the chairperson, Professor Parthapatim sir. I have got many interviews today. So my topic is challenges created by globalization and privatization under the concept of state in the Article 4 of the Constitution. So as you know, the Article 12 state about the very cardinal principle of the state. And we can only apply the fundamental rights against the state, not against any private. So, but the present situation is that the India has taken the policy of privatization as well as the globalization, and that is called the LPG, globalization, privatization, and that is the policy taken in 1991. After that, India became the one of the open market country where any multinational company can invest or they can start their business there. And so by this, what happened? Now the Article 12, the extension of the Article 12 is required now. What we have seen in Ajay Hasia versus Taylor case, that very Supreme Court has fixed some parameters, six particular guidelines, and nowadays some of the entities are coming which do not come directly to this particular parameters. If you see the BCCI case, BCCI versus Winner India case, where we see BCCI was not taken as a state entity, but it is not true. It is not that particular judgment is controversial because there is some element that BCCI represents the India, and it is the flag holder of the Indian cricket. So the globalization has blurred the area of the state. Area of the state is now expanded, and it has blurred the boundaries of the state and the state entities and the private entities. So I have made some research question on this. That the research question are very important and pertinent to this paper. That to what extent has globalization or privatization affected and extended the definition of the state? Second, to what extent the court reviews the privatization decision without enforcing the executive policy, executive or the legislative policy? Does the current judicial approach adequately protect the stakeholders such as the labor, investor, and the public? Fourth, should the privatization institute the government by the specialized jurisprudential framework distinguished from the general administrative law? Is there a need for comprehensive legislation regarding the privatization in India? So if you see various kinds of distribution or entities, they became privatized. You can see recently we have now news coming up regarding the railways and other entities that became private now. So the question is there jurisprudential or judiciary has made a proper or clear approach? Until now, judiciary has taken the privatization as a policy. Therefore, they do not interfere generally on the private. So if any university, any college that made private later on by the authority, by the administrative decision, the generally judiciary do not interfere because they think that the policy decision. But we have to think about that what are the right of the employees, what are the right of the stakeholders, what are the right of the students, or like any institution, the regulated students or the labor. So what will be their position after that? So this is the present situation which globalization has made in our way, and that we have to think forward. Presently in India, there is no such judicial approach or fixed principle. Judiciary normally the judicial restraint, the policy of judicial restraint from making any kind of decision or any kind of in the privatization sector or decision privatization is being given the authorization or judiciary is reluctant to interfere in the matter of the privatization. Now, there is the most important problem, the research problem we can say on this area. There is lack of uniform judicial standard on privatization. So there are some cases like Balco Limited versus India case, and there are other cases in which the Supreme Court has stated that it's a policy decision. So let's do not interfere in that matter of regulation. Secondly, judiciary has
Last one.
Okay. So now the judiciary actually mentioned that is the non-interference policy. We say that there is a non-interference policy because of the privatization is one of the legislative or the policy or it can be called the executive policy. Okay, I should mention some cases like Balco Employees Limited, Union Limited of India case in 2002, where the Supreme Court stated that often the validity of the investment and reaffirmed the principle of economic policy decision of the government and generally beyond the scope of the judicial interference. So therefore, there are another case Center for Public Interest Litigation versus India case 2003. Here also, Hindustan Petroleum Corporation Limited was privatized, and therefore some share of the corporation was sold out, and that was also questioned. And Supreme Court decided that that should not be interfered. So I can conclude that there should be a good, robust judicial principle which can eliminate particular. We cannot say that privatization is one of the key elements, but it cannot be used. It can be used consciously. It cannot be used whimsically by the executive. And there should be some process. And from the procedural view, from the procedural aspect, the privatization will be regulated in a better way. That now the non-present there is a lacuna for the judiciary or the other elements. Or in the judiciary hospital is concerned, there must be some state jacket, there must be some formula, some area that has to be addressed.
Thank you, sir, for the exciting presentation. Now I would like to request our next speaker.
Yeah, I'm here to answer question.
No, later. Do you have anybody question?
Now I want
Nowadays, it's the important.
Very
India is the ECI is representing India, but it's not a state entity. Next presenter.
Okay, now we are moving forward, and I would like to request our next presenter, that is Sreshi Malagar, Assistant Professor of Sociology, Uttarayan College of Law. Yes. Start. Good afternoon.
Yes, sir. People would like the nomenclature of your class.
Good afternoon, Father. Scholars and participants. It is my privilege to conduct this national seminar on the theme that is book, family room, and the urgent. We often celebrate the information as a force that influences and also links the whole world in a single thread. But condition without equality can deepen the resisting execution that is happening and the discrimination that is happening all over the world. If the limit of access determines participation, then inequality in access becomes inequality in rights. This is where the promise of limited human rights is fractured. Digital globalization has undoubtedly transformed the contemporary society as highlighted in this study. It is
It has enabled global communication networks, digital activism, and increased transparency in governance, allowing the individuals to mobilize around the issues of human rights and social justice. However, certain advancements in the infrastructures are also very much accompanied by the serious concerns regarding the privacy, equality, and governance, particularly due to the growing consideration of the digital power within the state and the corporate structure of the global economic system and also the market system. It would not be wrong to say that the humanity has crossed an extraordinary threshold within a single generation. India's digital transformation exemplifies the paradox. On one hand, we have built one of the most ambitious digital public infrastructures like Aadhaar, UPI, DigiLocker, and coding, recognized globally for scale and affordability. On the other hand, persistent divides across state, across caste, gender, class, and region, and the diaspora networks, reveal how digital systems often mirror and rectify the pre-existing inequalities. The digital systems, which were once peripheral or experimental, are now more likely to be very life-centered, and they are now impacting the livelihoods of the common people. The most visible manifestation of this contradiction is the digital divide and the gap between the digital literacy. Inequality today is often shaped by unequal access to digital infrastructure, technological literacy, and economic resources, which disproportionately affect the marginalized communities. This divide is not technical, it is deeply rooted in our society structures, the class structures and the class hierarchy in society. In developing context, digital exclusion reflects broader inequalities, excuse me, based on class, caste, gender, and geographical regions. This paper highlights how these structural disparities result in unique participation in digital spaces, thereby restricting access to opportunities, information, and service. Therefore, the digital inequality must be understood as an extension of existing social hierarchies rather than an individual issue. Adoption of approaches for improving government services. Quality requires systematic and integrated policy interventions for reducing digital exclusion. Primarily, it is essential to develop a standardized evaluation system for talent public service and quality-based or empirically driven models. This should serve as a platform for comparison, continual development, and strategic long-term planning. Furthermore, centric services and the design of the policy and everything that has grown, and that is in the power of the and power that is in the hand of the sorry that is the power that given to the state and authorities. Sorry, they are like citizen-centered. Citizen-centered. Service design technology for ensuring accessibility for all Indians. Because for ensuring accessibility for all Indians, particularly the Asian population and individuals within the digital space. Investments in security infrastructure, including the feedback system and behavioral data analytics are also essential for increasing public trust and satisfaction. Finally, the service quality indicators should be included in government performance evaluation systems. The KPI framework, especially like the National Indicator Framework, the Viksit Bharat 47, Sonagra Shiksha, ACBIs, KPI standards for IPOs, are providing guidance to the public agencies to concentrate on this critical citizen-centric outcomes.
Yes, madam. 3-4 lines will just give us what is exist of you?
I have focused on the digital discrimination and
That I know, but finally, your finding or recommendation.
so in conclusion, the last part I have recommended some things that the government should focus on, like the government should work on rural areas, and they should bring development from the last areas to bring in uh, the rural structures and the urban structures. They should work together on the overall development. Thank you. Thank you.
Thank you, ma'am. Now, I would like to request our next speaker, Shrinka Das, Assistant Professor, Uttarayan College of Law. Ma'am, please.
Actually, civil rights should be announced. That I consider in season one. I have not going to
Good afternoon, all the interns present here. My name is Srinka Das, Assistant Professor of Law of Uttarayan College of Law. For this seminar, my topic is privacy under threat in the digital era in human rights perspective. So first of all, I want to highlight one quotation by the famous Colombian writer and journalist Gabriel Garcia Marquez. He said that all human beings have three lives: public, private, and secret. So privacy is not a mere option. It is considered as a fundamental human right as well as it is an essential element of human dignity and individual freedom. So in today's digital era, digital privacy has become an important concern. Digital privacy means the ability of an individual to protect and control their activities, personal information when they use various technologies. So the concept of privacy comprises a distinction between the private and the public circles of life, a distinction made by the great philosopher Aristotle. It means that the personal and family matters should be protected from any unnecessary state interference. So now in our day-to-day life, data is created everywhere. Mainly, there are two types of data. The data we give immediately and the data that is automatically created when we perform some activities due to the availability of the internet and technological advances. So data has become like a new type of currency, but it is unfortunate that most of the people do not fully realize the value of their data. But many multinational corporations, they are ready to pay to access this kind of data so that they can flourish their business. So therefore, the issue raises a relevant question: do people really have control over how their personal data is accessed and used by others? Now, in the digital worlds, privacy has become an integral part of our life, and which is already safeguarded by the Article 12 of UDHR and as well as Article 17 of the ICCPR, as well as Indian Constitution does not explicitly mention privacy as a separate fundamental right. It has been interpreted by the judiciary and recognized as a part of Article 21, that is the right to life and personal liberty. Now there are some research problems which are strengthen the personal privacy in the matter of family, worship, and household affairs, as well as kings were also bounded to uphold these protections. Now coming to the international perspective of privacy. So already Article 12 of the UDHR as well as Article 17 of the ICCPR protect or state that the right to privacy is a fundamental human rights, as well as there are international convention. Last one. There are international convention on the protection of the rights of all the migrant workers and members of their families, 1990, but it protects migrant workers migrant workers' privacy by prohibiting unlawful interference with their personal life. But in reality, the migrant workers they do not even know this kind of rights which is available for them, as well as there are OECD privacy guidelines, and so it address more artificial risks like the national strategies and risk notification, though remains not binding.
Thank you, sir.
Second, I'm only in one question. Can you define privacy? What is privacy?
So privacy means the ability of an individual person to protect and collect, to
Simple
protect
that
and
in one line or in two words.
it means the ability to protect individual's personal information like personal data while using technologies.
Thank you.
Any question from the audience side? Thank you, ma'am. Now moving forward, now I would like to our next speaker, Dr. Monalisa Shah, Assistant Professor of Law, Department of Law, University of Portland. Please.
Very good afternoon, sir, and audience. I'm,
Well, please.
I am Monalisa. I am teaching at the University of Portland. I will be discussing my paper titled Trade and Wildlife in a Globalized World. So my paper is six subsections where first I discuss identify stakeholders, talk about animal trade that has evolved, identify legal structure at an international and national level, and try and see if the judicial pronouncements are in tune with protection or use of animals as a resource. So I hypothesize that animal trade has evolved over the years, and though it might seem otherwise, exploitation has continued, except that in a different market. Policies and laws that are there concerning animals, they still have a premise on anthropocentrism, that is, to subordinate animals with human beings. So I speak for a large portion in my paper on how animals have been considered as an inferior species and how humans focus is primarily on exploiting anything that it considers inferior. So in the olden times, we had animals being used for transport and of course in the farm. But this is one sector which has remained almost unmodified and it still exists today. In the middle, however, what has changed is use of animals in the hunting sector, in circuses, in fashion industry. So there we have had some sort of regulation where we have tried to put down on cruelty. The newer sectors that we have modified into is tourism, a variety of tourism, where we move beyond the zoos and this exotic animal pet exploitation, and we justify exploitation of animals for scientific research and to meet food insecurity. Now, if you were to look at all the kinds of trees I mentioned, you would broadly categorize them into three sets of animals, or three camps. One is the wild animals, where we consider them necessary for maintaining ecological balance, and therefore they have given the highest protection. Now, the performing animals that we see in circuses, that has had a significant prohibition, but where the Supreme Court and the law seems to prioritize economic development is use of use of animals in farm and transport sector. So I was trying to present this in the legal structure. Of course, we have a constitution policy, which we speak about states' duties, citizens' duty to protect environment and wildlife. But particularly, there are two statutes of importance. That is the Prevention of Cruelty to Animals Act 1960 and the Wildlife Protection Act. Now, what is very nice and a major shift in the policy is we identify cruelty, we go on to define cruelty. But what the law does not talk about, in my understanding, is whether animals should be always used for meeting human needs. That is not something which the law questions. The law questions on how intensively can you use animals, okay? it does talk about, positive obligation to impose, to not subject animals to unnecessary pain. It explicitly bans use of performing animals, but it speaks nothing about animals that are used in agriculture or transport sector. And we still continue to justify killing of animals to meet another human-centric need, that is religious purposes. Now, the next statute that is of significance is the Wildlife Protection Act. Now, the Wildlife Protection Act has had major changes, especially after the 2022 amendment, which is in sync with the Convention of International Trade on Endangered Species. Basically, now we have four schedules, and of course, it talks about flora, but my paper is limited to understanding fauna and its exploitation. In the four schedules, we categorize animals according to the endangered level, and we try and prohibit exploitation, hunting, etc. And the CITES, which is the major convention. Yes. Okay, thank you. The CITES, which speaks about how habitat alteration is going to be prohibited significantly. Now, if you look at Wildlife Protection Act, it emphasizes a lot of zoos, and zoos primarily focuses on conservation. But when you question why is conservation required, because all along I'm arguing for non-interference of humans in the life and the world of animals to grant them agency. We belong in a shared world, and animals should also have this space. But conservation is prioritized by the government stating that we have destroyed habitats, and now we need to almost do controlled breeding so that we can reintroduce these species in the natural habitat so that we do not have extinct species. So there are lots of other policies here, but quickly I have identified four judicial pronouncements which are of significance. The ivory traders, now we don't see ivory items in our houses. So when there was a ban which was placed on ivory traders and ivory traders protested, the government was very, very clear that there is no fundamental right to trade when it inherently harms ecology. That was in the ivory traders case. Now in the Nagaraja case of 2014 also, when we were talking about using animals for performing, like gaming and all, and they had tried to defend it as a cultural practice and assert property rights on animals. Then again, Supreme Court came down heavily and said, we are moving away from welfare of animals to recognizing the rights of animals. But if you look at this last case before I conclude, I understand. The Sansar Chand case, this is a poaching case. This case, Sansar Chand was a wildlife trafficker who was granted 5 years of rigorous imprisonment, and it is the maximum limit. But when the Supreme Court keeps harping on the fact that we cannot use animals for satisfying human needs, but it does not recognize the ground reality, where the ground reality is it's a very structured criminal enterprise. It is not proportionate. So anyway, my point is that the law has been upheld, but it is not in proportion to the significance of crime that is taking place. In my conclusion, I have my concluding para would be, laws have evolved, markets have also evolved. Laws have restricted use of animals in certain sectors, but as long as it is not harming humans' economic interests. Wherever it is contradicting humans' economic interests, laws have conveniently focused on subjugating animals to anthropocentrism doctrine. Thank you, sir. Yes.
What is your take on the second animal welfare board case, which overruled actually the case which we have referred for?
So
And do you think that rule is a performing animal?
I do think so. It is because
That 2014 that was overruled by another constitution. That is the animal welfare board versus.
right, sir. So I still do think that the good performance is called human and spectacle. There is no inherent benefit in continuing this, and this entire focus on how animals are there to satisfy any kind of human need, even if it is for something like tourism where we are focusing on national parks where animals are not per se physically interacting with humans, I still do think that animals deserve their own space and do not need consistent interference with humans. So I take your suggestion and will look that case up in detail. I have not looked that case up in detail. That is one thing I will take a feedback and I will develop upon that. Thank you,
Yes, any
sir.
other questions from the audience? Thank you.
Thank you, sir.
Thank you, ma'am. Thank you, ma'am, for such a wonderful presentation. Now, I would like to request our next speaker, Rohan Mukherjee, Assistant Professor of Law, Sureshwar Datta Law College, University of Kolkata.
Good afternoon, everyone. I'm Rohan Mukherjee, Assistant Professor, Shorter College, University of Canada. Today, I'm speaking on the safeguarding of human features, with special reference to the PCPNDT Act, Conceptual and Developmental Diversity Act, and Gender Discrimination Legal Development. Here is a paradox of progress, the constitutional rights and the draft. The de jure and the de jure institutional context centuries and substitution of the sati, child marriage, 20s era, Halaramon right, stop the remarriage of the widows. After that, post independence, the constitutional guarantee protection of life, personal liberty, civility, equality before law, articles 14, 15, and 20. The real ground reality is a technical practice. About the PCPND Act, it's about the basic ultrasound machines and the other technologies to rectify or determine the fetus is female or male. To what sex it's a sex determining case. The widespread of the introduction of the wild ultrasound technologies in late 1990s in developing India. and with widely spread in the rudely in social structure and the every area. In recent times, rural area also is under some technology that the other tastes. The results female infanticides transition into female fertilicides rupees 1 crore industry. Data point ratio, it's the declining ratio of the fertilities and abortion of the female. The socio-economic drivers, the rural economic calculus. The male child considered as an asset and the female child always considered as a liability. That's why we choose 50 rupees for the abortion and rather than the 50,000 rupees for the life. And in the 12 million girls were aborted over 3 decades due to deep-rooted economy. Why male child considered as asset? Because the view is essential old age social security of the parents, absence of the broad state system, and given access to productive income generating jobs permits and brings social wealth into the utility of the household work and the marriage market. And for the females who consider as a liability for their families, leave family out after the marriage and no long-term responsibility to the family, subjected to the inheritance legal dowry system, which included the cost of loan. Next slide talks about the objective of PCPMDT Act. This PCPMDT Act came into 1994, and thereafter there is 2 amendments in 2003 and there is a 6th amendment in 2011. But after 1994, when the PCPMDT Act came into after the Parliament passed its Act, after the implemented, there is an absolute ban of the completely prohibits the prenatal sex discrimination and the commercialization of the sex discrimination test. But in recent times, we know that not only government hospitals, not only government clinics, every private clinic, every small private clinic have the sex discrimination test, the gadgets, the mobiles, everything. And the strict regulation mandate the registration oversight all the genetic clinics and laboratories under some vision, including banning the portable on missions and the prohibition. Yes, the ground reality. Section 5 of subsection 2 of the PCPLDT Act talks about there must not be any signaling method. Right? Suppose there is a test for the medical purpose. In that case, there should not be any signaling method what doctor or regulation. But there are examples where we explicitly target cover all out languages used by the doctors, even the law. Example like using religious techniques. It's like Jai Shri Krishna. And it's Jaimadhan for girls. And there are special sweets like pera, jalebi. Yes, everyone thinks about the one examples. There is an article about the PCPD and abortion related document examples which published by the G Hindu in 2015. Yes, there is a drinking gap in private clinics which may be done with the compliance of the pathway, that is mandatory registration. Mandatory registration of the clinic in under section 18 of the PCPD Act. The informed consent of the mother and the absolute non-disclosure of this individual. 30 seconds. Okay. Next, and there is a one record of Form F. There is a 2 case laws, one is from Gujarat and one is Dr. Surin COVID. And one case law says section forms say why absolutely or strictly implemented in every clinic. And there is another thing, if there is any which is present in the Form 5, the absolute liability on the doctor. There are some suggestions, 2 or 3 suggestions.
Just 15 minutes to okay.
Okay. There are suggestions. One, there is a campaign must be going on this value girl child. We know there are campaigns about the Beti Padhao, Beti Bachao. I think the third is Beti Bachao, Beti Padhao. And there are something like that. But there is no value girl child campaign needed, and there must be empowering the National Commission of Women and the state commissioners. And there is one other authority which we don't know much about it, there is an appropriate authority which mentioned in the section 17 of the BCPMBK Act. We should give more power to the appropriate authority to take steps in the rural areas and the completely abolish this sexual test in the root cause. Thank you.
Pachaligaon University is taking a lead role. The Vice Chancellor is woman, Professor Shachiti Mukherjee. Law Department Secretary Shatulpa Ghosh. But do you think that you are fair to those parents who don't think that girl child is a liability? Because I have a daughter. I never thought that she was a liability.
Sir, it's not for all, but
Why are you generalizing?
no, I'm not generalizing, sir, but there are a ratio of 70-30. Who thinks that girls child are diabetes?
So where you have collected this 70?
No, it's generalized. I'm not collecting any issue. I'm not.
Thank you.
Thank you.
Any question?
From audience, any question?
Thank you, sir, for a very nice presentation. Now I would like to request our next speaker, Ms. Jyoti Raj, Assistant Professor of Law, IILS. Please.
Respected Chair, distinguished faculties, and my fellow participants. Very good afternoon to one and all. The topic for today's presentation is globalization, invisible victim, and eco-feminist legal framework for protecting indigenous women living in the extractive zone in the global governance. Before I proceed, I would like to begin with the description of a woman who wakes up before dawn, walks through the forest for 2 hours to collect water for her family. She knows the name of every medicinal plant in the hillside. She is the living library of our community's ecological knowledge passed through the generation. From the perspective of international law, she is having a name that is, or she can be defined as completely invisible. I want to talk about that women, the indigenous women who is living in the extractive zone in the globalized era. I want to argue that her invisible identity is not mere accident, but it is a structural failure of our legal system, both domestic and international. We live in the era that has produced remarkable human rights instruments such as the United Nations Declaration for the Rights of the Indigenous People, the ILO Convention number 169 that obliges the state to to take the consent of the indigenous community before approving any kind of project on their land. But here is the paradox. Both the instruments speak about the indigenous community as a single, undifferentiated collective. They are gender blind. They do not protect the separate voice or the consent or rights of the indigenous women who live within those communities. Therefore, the FPIC, that is the free, prior, and the informed consent, which is supposedly the most important procedural safeguard from at least the forced extraction, is routinely conducted through male-dominated consent. Women are excluded from this group. The community formally consents and the women never spoke. This is not a formal consultation, this is a legitimate disposition. If we talk about our constitution, then the constitution is not silent on these questions. We have the Article 21, and the Article 21's interpretation given by the Supreme Court in the case of Subhas Kumar versus State of Bihar declares that the right to the Article 21 also includes the right to pollution-free water. The precautionary principle, the polluter pay principle are all the part of the Indian environmental law. But if you talk about the Samartha judgment, which protected the land rights of the tribal communities, the PISA Act also mandates that the Gram Sabha must consent before any kind of mining is taking place on their land. The forest right also recognizes the community forest right of the individual. Yet, none of these instruments mandates a credible disaggregated environment impact assessment. Not one requires that at least half of the population in the consultation community should be women. Neither of them classifies the loss of medicinal knowledge or the loss of water destruction or the gender violence that follows the mining tax as a distinct justiciable legal harm falling on the indigenous women. The constitutional raw materials are available, but lacking is the willingness to use it from a gender lens. My paper presents three concrete reforms. First, we must qualify gender extractive harm as a distinct, separate, justiciable legal category. Recognizing that the harm falling disappropriationally on indigenous women due to the extraction are human rights violations of the indigenous women. India's Supreme Court had done this before in the Vishaka versus State of Rajasthan. It created binding guidelines to protect women from sexual harassment in the workplace. The Supreme Court can do it again by laying down important guidelines to make sure that the indigenous women are consulted in the decision making process or protecting them from any kind of harm which the extraction can follow. So these were some of the suggestions from my part. Thank you.
Any questions, sir? Any question from audience? Thank you, ma'am, for such a great presentation. Now I would like to our next speaker, Dr. Sharfil Chakraborty, State Aided College, teacher in law at Whitefield Law College.
Good afternoon, everyone. Good afternoon, everyone. I am Dr. Shaitan Chakraborty, State College teacher at Whitefield Law College. The title of my paper is A Legal Approach on Sexual Violence Against Women at the Workplaces under the Global Perspectives vis-a-vis Indian Scenario. So, women, the most vulnerable sections of the society, and it is our duty to preserve and protect their right and as well as their respect and also their dignity and honor. It is our duty. And unfortunately, the harassment, especially the sexual harassment, are going on very increasing rate against the women at workplaces, not even in our country, but throughout the world. And it is already been considered in India that sexual harassment it is a professional hazards issue which actually tries to derogate the conditions of the working life of the women and even the entire environment of the working conditions of the working workplaces. And as for the United Nations conventions of their their decision is concerned, they have already adopted various treaties and conventions like CBPBU in order to protect the rights of the women. Still, this disease is going on in our global civilized society. And obviously, in India, this sexual harassment is clearly violation of the fundamental right as guaranteed under Article 91 of the Constitutional Law of India. Sexual harassment. Obviously, the Supreme Court, the Honorable Supreme Court, developed the definition of sexual harassment in their own way. That is, any kind of sexual favors, any kind of sexual remarks, or sexually colored remarks when pornography, any kind of physical contact, like verbal or non-verbal against the women, that is not considered as a sexual harassment of the women at the workplace. And this type of harassment can be done. There are some parameters, some causes are there, like privileged treatment to be given to the workplace, threat to the retaliation in the workplace, threat of one's professional positions, and impeding with work, creating a menace offensive and hostile work situations. Well, so apart from this, international legal framework has been done, like the United Nations conventions and General Assembly conventions, they have adopted so many rules and regulations relating to the protection against the violation of women at the workplaces. And the CEDAW is the most important convention relating to the women against the protection of their rights. Not only that, Beijing Platform for Action and the ILO report, the ILO Convention report, they have already discussed and they have already given the statistics that at least 23% population of the working women and they have been victim or they have been witness to the sexual harassment at the workplace in the different parts of the world. And as for the Indian scenario, there are lots of legislations that there, especially for the protection of the rights of the women who have been sexually harassed. Specifically, that our constitutional law of India, which actually starts with the word like we the people of India. There's a people, the protection of the people is a paramount consideration of the constitution. And we know we have some articles like Article 21, is right to life. Article 15, Clause 3, there's a special protection. Special protections can be given against the women in order to protect from their being sexually harassed. And Article 19(1)(g), their fundamental rights to get protected and to be protected. And not only that, the Part 4, that is the DPSP, Directive Principles of State Policy, also provides various articles in order to protect the rights of the women. And besides, among them, Article 39A, that's the practice of free legal aid. Article 41, 42, and 43 is a very important article relating to the constitutional law of India in order to protect the rights of the women. Not only that, the penal provisions, like Indian Penal Code, now has been transformed into BNS, that is Article Sanhita 2023. There are lots of sections relating to the harassment of the women, like section 354, 354, A, B, C, D, and these are sections incorporated into from sections 74 to 78 and section 79 of BNS, that previously was section 509. All these provisions were really deals with the protection of the women against their sexual harassment. Besides this, there are lots of industrial laws are there. Indecent representation of women at Industrial Employment Standing Orders Act are there. The National Commission for Women's Act is there in order to protect the rights of the women. But the most important legislation to the protection of the women against the violation of sexual harassment at the workplaces, like we, in short, we used to say the POSH Act, that is the Sexual Harassment of Women at Workplaces, like Prohibition, Prevention and Redressal of 2013. After the verdict given by the Vishaka State of Rajasthan Justice Verma Committee has given us complete report, and on the basis of that report, this act has been implemented and some guidance has been provided. In this act, the position of the women or the status and character of the nature of the women, it can be anybody. That is the women of any category or any discipline. Like might be the domestic work helper of like women, they can also be included within the purview of this statute of the Sexual Harassment Act. And not only that, the internal committee should be set up by the employer, and all the complaints should be should be completed within 90 days. The employer should be given the compensation to the victims, and there are so many guidelines provided under this act. Although there's some lacuna for implementing this act, there's a lack of understanding of the awareness of the program, illiquid investigating committee, ambiguity in the hearing of the standard of proof, and need for the gender neutral sexual harassment act, and problem of anonymous complaints. Yes, sir. So these are the problems that there, and like I said, some judicial verdict is also being given, like Vishaka's case, we know, and there are the Appeal Export Promotion Council versus A.K. Chopra. Yes. So many guidelines have been already provided by the Supreme Court in order to protect the rights of the women. But still, at the last of my presentation, I would like to give some suggestions that fair and comprehensive sexual laws should be provided, parameters should be given, a training program on awareness should be done, and establish a confidential reporting system, and so on, so that we can remove this disease from our society. Thank you very much. Thank you, sir.
Any question from the side of audience?
If you have any question to any of the presenters, so please come up with a question.
Well, you mentioned that proceedings usually get concluded in 7, is supposed to get concluded in 70 days.
No, 90 days.
90 days, but it never does. So usually when the victim, the aggrieved woman, leaves the institution, the ICC, if it has found the respondent guilty, who is going to finance the consistency of the case that has to be dealt with in the courts sometimes? Because sometimes the victim has graduated, like I'm talking about a university setting. So can you throw some light on how this funding of cases, because I see a lot of ICC struggling with finding the finances.
This type of committee has been always set up or doing by the statute. Obviously, the administrative action, so far I can understand, but the judicial actions is already provided under the separate statute and it has been provided to the court of law. So obviously, there is a problem there. Who will do the finding of financial assistance and all? That's the question.
Yes, because the ICC usually doesn't have the fund from.
Doesn't have the fund, yes.
So if they want to fight the case, because usually the respondents also files a case of defamation.
Yes.
It's a very tedious thing. In case you
Yes.
really
They can help with the aid of the legal aid, but actually legal aid is not enough because
the
the
respondent
Not lacking.
exactly.
because when the respondent is economically well off,
Yes.
it becomes very difficult for the ICC to pursue, and tragically the aggrieved person has left.
Yes.
Oh,
And if you could explore it as,
victim centric.
but who is going to provide the money?
There is a big question there. The problem is still going on. So these are some of the mechanisms are there and has to be removed by the implementing some strengthening of laws and writing to this act.
It's a very calculation of funds.
Yes.
Thank you.
Okay.
Our technology is not fully developed, so that we address those issues.
Any other question? No question. Thank you, sir. Thank you, sir, for such a nice presentation. And so this is the end of the session 1 of our session 1. So I would like to request Professor Dr. Parthav sir to address the gathering.
Good afternoon. Only 2-3 things. About request some of the presenters who read out. So, okay, some of the things you have to read out, but give a in any national seminar, international seminar, give a extemporize it. That is my humble submission to some of the presenters. And about other matters, like only one thing I will respond the first presenter, that the state and non-state. See, this is a situation where huge amount of money, that is the BCCI, but it is not a state under Article 12 Constitution of India. So, in that way, that the government should come up with a legislation, and then under a statute, that board of BCCI should be again re-established and to be elected. And then all qualifications are also to be prescribed for the office bearers. So it means that only without somebody does not play cricket and not touch the ball or bat, becoming the chairperson others. So this is a kind of discretionary power, absolute arbitrariness. So that is to be regulated. And in that way, even officially, unofficially, it is a slightly in our mind that BCCI is representative of India, and even all the international, all the cricket competitions, this is sending the teams, but it is not official. It is not a state under Article 12. That is a very bizarre situation. Yeah, and okay, this much. And but I will request, there is a recent development, not from the state and non-state entity. There is a 2021 most probably, there is a judgment, Kaushal Kishore versus Union of India, where the Supreme Court is a 5-judge bench. Most probably, Justice Ragaratna or Justice D.Y. Chandrachud. It says that for the violation of fundamental rights, in any violation of fundamental rights under Article 21 or 19, so there are non-state actors, non-state entities also would be liable. And in those cases, if somebody's right to life and personal liberty or right to freedom are violated, then that person can file a petition against non-state actors. So this is a kind of a paradigm shift, and making this fundamental right jurisprudence from verticality to kind of horizontally. So this is a major development in that field. But I appreciate some of the remaining presenters. All the presenters really they have done hard work. They have valuable the interpretations inputs I appreciate. But some of the other presenters, it was more satisfactory to me. And now, as part of the duty, that the best presenter is to be selected, but I am not here to discuss it. It would be handed over to Dr. Satyarupa Ghosh, the coordinator and head of the department. She would announce it at the valuation. Thank you so much. But I enjoyed all the presentations. Then I also, it was an experience for me from some of the presenters. Thank you so much.
Thank you, sir. And inspiring address. So this is the end of the session 1, session 1. Now moving to forward with the technical session 2, panel session 2. Now we are having our person, Dr. Rakesh Mandal, Assistant Professor, Department of Law, Bardhaman University.
Thank you so much. Please allow me to read
Can I take this? So now we will taking the session 1. First of all, I would like to request to come over the our first speaker, Ms. Shushmita Haldar, Assistant Professor of Law, WDES, Government Center of Legal Education, Hooghly.
Good afternoon, everyone. Good afternoon, my dear colleagues. Good afternoon, Chairperson, Dr. Professor, and good afternoon, other faculty members. Now, today I will present my paper. The title of my paper is How Globalized Are the Human Rights Revisiting the Third World Approach in the Era of Globalization. So, may I start right now, sir? How globalized are the human rights? Globalization of human rights is often criticized by some scholars on the ground of Eurocentrism and Westernization, the impact of its Westernization. Instrumentality of human rights at the international level is concentrated on the hands of the superpowers. As a counter-hegemonic move and intellectual political movement, namely the third world approach to international law and the third world approach to the human rights, it is a part of the third world approach to the international law, and it was originated, which can be traced back to the Bandung Conference of 1955. And during that time, the first phase of 12, it was originated. At the outbreak of Cold War, in between the two worlds, some countries decided to be neutral, to remain neutral. Those are called the Third World. Aftermath of Cold War, Third Worldism lost its relevance because there was no such concept of the two worlds, and then obviously the relevance of Third World was in question. But still, it remains in existence, denoting the underdeveloped countries, which were experienced by the colonial operation, loss of resources and lives. During the first phases, the scholars of Third World approach were skeptical about Eurocentrism of human rights, especially of civil and political rights. The most influential impact or effect of 12 can be found in the adoption of UN Declaration of Rights and Duties of States, 1949, the Charter of Economic Rights and Duties of the States, 1974, and the 1986 Declaration of Right to Development. Mark stress was put on the right to development, right to self-determination, and also the economic and social rights, the minority rights, the refugee rights. The first formal international instrument on human rights, that is the UDH, Universal Declaration of Human Rights, 1948, it was also criticized by the 12 scholars, and it was influenced a lot by the contribution of the third world. And the 12 scholars have contributions to the conventions on the migrant laborers, refugee conventions, etc. In this paper, I have adopted the historical approach to question or that to question whether and how far is the 12 approach relevant in this contemporary global order and in this era of globalization. So basically, what is globalization? According to the UNDP Human Development Report 1999, globalization is a process of shrinking space by shrinking time through disappearance of borders. That means across the globe, different countries will become close to each other. And globalization doesn't mean that some countries of global south, one minute, okay. So just I'm I'm trying to confine it because actually the twine approach it is very much wider in nature, and so I will just point out the important portions. Basically, if we go through the history of globalization and its impact on the human rights approach, human rights it was influenced by the global north, mainly the superpowers. And what about the voice of the global south? Whether those conventions which have been formulated by the representations or representatives of the global north, whether these can be implemented in the developing countries or the underdeveloped countries. That is to be determined, that is to be evaluated. And for this issue, the 12 scholars raised their voice. And just a minute, ma'am, I'm concluding. But though the 12 scholars, their approach is anti-colonial, anti-Eurocentric, and anti-Westernization. But the main problem of 12 scholars are they are very much concerned about the global order or the aspects of human rights aspects of the global order, but they are not very much concerned about the human rights violation in their own states. They are negligent about the human rights violation of their own states. They talked about the social, economic and social rights, but whether they have proper infrastructure to comply with their own concern about economic and social rights, they were not very much concerned about that infrastructural portions. And they do not concern about or they do not focus about the caste discrimination and the Dalit issues. And the 12 scholars, their methodologically, they were not well organized. And most importantly, the voice of the 12, it is from the global north or from the scholars of the superpowers, that means the Harvard, scholars of the Harvard University, US. Though in India, the National Law University NUJS, National University of Medical Science, Kolkata, they have introduced a paper called Trial in the International Law Approach. Okay. But majorly, the voice of the 12 scholars, it is mainly from, it is not very much it is not having very much authentic representation from the global south or the actual third world countries. Thank you. Any question?
I will later on conclude on it. So, audience, if you have any question, you can ask. Otherwise, we can go to the next presentation.
Thank you, sir.
Thank you, ma'am, for such a wonderful presentation. Now moving forward, and I would like to request our next presenter, that is Miss Rachana Garg, Assistant Professor of Law, Highway and District. This is an announcement. Is there anyone from the technical session 3 and 4? Is there anyone? So, technical 3 or 4? Ma'am, I think you are in technical session 4. So, ma'am, according to our chairperson, you can give your presentation. Ma'am, you can start.
A very good afternoon to everyone present here, to our respective chairperson and every other faculty members and other speakers. My name is Rachana Garg. I'm a faculty member at Professor Studies Kuch Bihar, and the paper which I am presenting today, the title is Digital Globalization and Human Rights, Navigating the Promise and Peril of a Hyper-Connected World. So let me begin with a simple observation. When the drafter of the Universal Declaration of Human Rights set in 1948, they were responding to an era of state terrors on colonial violence. Digital world was something very new to them. But we are here talking about a world in which a private company in California would hold personal records of 2 billion people, in which a government would shut down or shut down the entire country or entire state by just administrative order by shutting down the internet. So yes, that's the world we are talking about. That's the digital world we are talking about where human rights must exist and which is very different from the world where UDHR, that is Universal Declaration of Human Rights, were written, that is in 1948. My central theme of my paper is that digital rights are human rights. It is not a specialized technical category which is managed by any information technology ministry, but they are the contemporary form of rights which are recognized and protected by any international law or the constitution. My paper talks about specific challenges. The first is privacy. There are two areas which I want to put forward, that is state surveillance and corporate surveillance. I also would like to put forward the landmark case of Kudaswamy, where privacy has been considered a fundamental right. The second challenge is the free expression. Section 66A of the Information Technology Act was struck down in the case of Shreya Singhal, which also showed how easily digital speech laws can become instruments of political suppression. The third one is the digital divide. Approximately 2.6 billion people in the worldwide have no internet access at all. In India, there is a wide gap between the rural communities and urban communities with respect to internet resources. Now, what must be done? That is, my paper talks about 3 to 4 reforms. The first is international human rights norms must be updated. Technology corporation must face binding human rights due diligence obligations, not voluntary guidelines. And closing the digital divide must be treated as a legal obligation. Now, I would also like to put forward my paper or my research by concluding that technology does not have its relation to freedom or oppression. It's only what we as a human being or it's only what we as a legislature and what we have thought that our thinking has widened the gap between or widened the digital gap to a very extent. And India has one of the most creative constitutional judiciaries in the world. The Putwasami and Anuradha Bazin, the Jammu and Kashmir famous case, are proof of that. But judiciary creativity alone is not enough. We need parliament for legislations and executive for completion. And the international community must put forward or must come forward for cooperation. The task of bringing digital governance within the framework of human rights law is one of the most consequential or one of the most controversial legal challenges of our generation. I hope this paper makes a small contribution. Thank you and have a wonderful day ahead.
Thank you, ma'am.
Okay, thank you. I have only one question, Rachana. As you said that digital rights are human rights. So, as well as every rights has a limitation. What are the limitations you also suggest regarding this kind of right or like the digital right?
So when you talk about digital rights or when someone talks about digital rights, one of the greatest limitations which we face in our generation is the negative use of AI which we are having. So what we are seeing today, clubbing of the photos, or which our Facebook and Instagram which we are having, of all the videos. So when I say about digital rights, I do not say rights without restrictions. Restrictions must be there, reasonable restrictions must be there, and each and every fundamental right we are having. So when I talk about digital rights as a fundamental right, I also talk about the restrictions which must be having. Thank you.
Thank you.
Any question from the audience? Thank you, ma'am. Now I would like to call Now I would like Dr. Subodh Daluta, Assistant Professor of Law, Government Center of Equal Education, University of Rotterdam. Sir, please.
Good afternoon, everyone. With the permission of the chair, I like to present my paper that is Rethinking Human Rights in the Post-Human Era, Generational Discourse. What I have tried to explore over here, that in general, the human rights development which we have till now from historical perspective, more or less are based on the generational study. More or less, we have discussed about 3 generations which we have, very popular discussions are there. However, 4th generation of human rights are coming now, and they are developing in very fast mode because of the improvement of the nanotechnology, biotechnologies, and the cyberspace as a whole. And what are the targeted zone or what are the hurdles we are to face in the future days? I have made a comprehensive, I should not say, limited study on that one. Okay, so the next slide. Redefining the subject of law. The first slide title will have why I have done this. Because by following the World War, Second World War in 1955-45, with the creation of the United Nations and the build of charter, the global rights framework around the human has been fixed and declared certain rights as the fundamental to the human existence. However, in recent decades, with the advancement of the nanotechnology, biotic engineering, and the what was like genetic discrimination, the new rights have been brought, and how that rights have been shaped, I have made a study in the next slide. Now come to the evolution of the fundamental rights or the human rights as a whole. I have given 3 generations. There is first generation, second generation, and third generation. Come to the next one. Yeah. This is a comparative study of the three generations which we have. The first generation focuses on civil and political rights. Second generation focuses on economic, social, and cultural rights. And the third one is solidarity and collective rights. And then I come to the nature of rights. The first generation is where state should not intervene those rights, right to vote, right to life, right to freedom of speech. State should not intervene. Whereas the second generation of rights are positive rights. Why? Where the state has to secure right to education, right to food, right to having health. All these are the second generations of rights. Now come to the third generation of rights, that is the group rights or people's rights, right to development. That is the group rights, right against environment degradation, environmental degradation. So these are the group rights. Now the key instrument under the international law, I have tried to mention those in ICCPR, and UDHR is the civil rights, that is civil and political rights, and the International Coordinator of Economic, Social, and Cultural Rights, and UDHR, obviously Article 22 to 28, that is the second generation of human rights, and the third generation of rights, the examples of third generation of rights under the international law, that is the United Nations Declaration of the Right to Development, that is in the year 1986. Now come to the next one. Why I have terminology term as a post-human, or what is the post-human era? I have tried to discuss this in this slide. The post-human, what is in reality is the human existence mediated entirely by digital environments and genetic insights. It challenges deeply ingrained anthropocentric tendencies. That means where people are not only considered about the basic rights, where people are thinking about how their privacy, their genetic rights has been violated by the other people's actions, not only the action by yourself, by the action of the society, as well or action of the other state which can be controlled by himself. Due to the globalization, this discussion has been done through globalization now in this session and the prior session are very much relevant to this one. Now go to the next one. Defining four generations of rights. I have tried to give four clusters. One is thematic rights, one is daily privacy, one is digital rights, and one is future generations. Yeah, sure. Why I have done this? Because these all have their own issues. And if I go for genetic privacy, just for an example, next one, and next. Genetic information and privacy. Why I have done this? Because right to privacy is a fundamental right, we all know these things. But genetic privacy and how genetic discrimination is implementing us or affecting us is very huge. If I go for an example of the genome of American legislature which we have for the protection of genetic discrimination, and the Indian legislature or Indian legal structure now what we have. Number one, we don't have any specific legislation. Number two, Supreme Court has mentioned in 2 or 3 cases where genetic discrimination should not be there in health insurance and employment. However, there are a huge number of incidents and practical evidence where that has been taken into consideration at the time of allocation of the health insurance. Last, just the question. Just last. Done. Yeah. Legislative mandates for human data. Genetic data framework. I've tried to mention this. That you have to enact not only the Data Protection Act, it's not enough for us. I should go for a genetic protective act which prohibits the genetic discrimination, like the American legislature we have, like Singapore we have a legislation regarding this. So that should be there. Number one. Number two, algorithm, the machine learning, algorithmic divisions which we have been around is always should be used for our benefit. There are two sides of everything. We are using the a short of two age, but how we are using I can remember in our school days we have a historical question that Bigyan is a Bigyan Ashirwad Odisha used to call like that. So that same question again comes into the picture. History repeats itself, we used to call it every day. But this is the same thing. Again, with AI, it's just double-edged sword. Whether we take the benefit or we go for the person condition, it depends on only the human. Though we are talking about post-human, but it is only controlled by the human. That has to be the decisive power. Thank you.
Thank you. Very nice presentation. I have many questions, but I cannot answer all the questions. Later on, I will discuss. First of all, one thing I would like to know from the Dr. Shogato Talukdar that if there is violence or infringement of genetic privacy, it may be happened by the state actor or not state actor. So, what may be remedy that can be prescribed in case of the this kind of privacy violence by non-state actors?
That is a very important. We always talk about state actors, violence, sanity, and fundamental rights. Many times called, but no, the violation caused by non-state actors is more prominent in this one, where data is going to the private sector, medical insurance companies, or anybody. They are getting. Just few days back, I have an experience that I have purchased a Titan sunglass not long ago. Suddenly, you received a call from the insurance, which is also controlled by the Titan, and they say that I have received that data from the Titan line. You have purchased sunglass over there, so we have taken that. So it's not that only the company you are giving the data, but the system concern also taking the data from there. And it's like that. The legislation, I think the legislation should be there. Number one. Number two, the person who are using data. More or less, the Indian scenario, the problem is the person who is we are using data. We don't have idea how we are using data. When I am uploading something into the internet, we think we are only using that one. No, that is not the case. We are uploading that into the cloud, and everybody who is accessing the cloud, they can use that.
We are giving the consent.
Yeah,
you are now eligible to use
that. Not in the nature. Though it's not explicit, implied one. Obviously, implied by uploading this. Thank you. Anybody else?
Thank you, sir. Any question from the side of audience?
Thank you.
Moving forward, I would like to request our next presenter, Abu Shaykh Mustafa Siraj, if I'm not wrong.
Siraj.
Abu Shaykh
Mustafa
Siraj. So absent. I would like to call our next participant, that is Anjuman Araka is Assistant Professor of Uttarayan College of Ludhiana. Yes. Good evening, everyone. Myself, Anjula, so today my topic is human rights violation and conflict in the era of globalization. So, we call that in today's globalized world, the armed conflict have been more technological, increased and involvement of non-state resulting in the primary okay. If we say that I want to in human rights to the civilian because the armed conflict will affect non-actors, the list. They are not attacked as the who are the citizens, who are the victims. They are attacked as the whole of the country. Okay, they didn't even state that who are the people and who are the main characters. They are all they actually categorized or they affect as a whole in one. Okay, but they should also follow the international laws, international conventions, which are particularly made for the protection of the human rights, for the protection of human rights protection for the civilians of the people, like the UDHR we have general conventions which particularly apply during the wars. So if there is non-state actors who are attacking country, who are particularly attack category of country. They should know that civilians should be protected. They should know that the civilian must be protected under this law. So, if we see in the progress drama, there are various new system like the drone attacks, the cyber attacks. Through this, they are advance their system. So, I have some recommendation for that. If they, the international conditions, the international treaties should be applied in more efficiently, and they should know that the human rights violations should be stopped in some area. Like the civilians must be protected. Also, the monuments, the instrument, the historical instrumentation protect the instrument. So that's all.
Thank you. We call the next.
Thank you. Thank you, ma'am. Now I would like to request Dr. Jeremiah Sen to Raj and Charlie Institute of Law. Again.
Good afternoon, everyone. With the permission of the chair, I want to share some aspects relating to globalization. The title of my paper, Globalization vis-a-vis Social Justice, Opportunities or Challenges in India. In the first section, Honorable Vice Chancellor Madam remarked one thing, that is 40 years we have passed. What would be the effect of globalization? Now we have to think. How globalization is affecting social justice, particularly in our country, whether it is a challenge or an opportunity. I have discussed this issue in my paper. Social justice, obviously, it eradicates different type of facts, that is the inequalities of wealth, opportunities, status, race, religion, caste, title, and the like. At the same time, it confirms social, economic, and political equality. The concept of social justice, it is stated in the preamble to the Constitution of India, and it is in the form of social, economic, and political. Without achieving social justice, economic justice is not possible, and without economic justice, political justice, it is not at all possible. That's why the concept is engrafted in the preamble to the Constitution of India in that way. That spirit is also highlighted in part 4 by virtue of Article 38, 39, and also in Article 46. The concept of globalization, how it affects, and now the entire world is a concept of one global village, that is Vasudhaiva Kutumbakam. In my paper, I have discussed some case laws where this question came: which concept we will give the priority when it is related with the social justice and globalization. After the adoption of open market economy in 91-92, when the Prime Minister was P. Narasimha Rao and Finance Minister was late Manmohan Singh, three concepts were there: globalization, liberalization, and privatization. When it is the insertion of this, lots of MNCs, they have invested money in different sectors, including education. Now the question is that whether they will achieve that optimum level of social justice, which is the spirit of our constitution. Under that context, I have discussed some case laws. Out of that, very famous cases are Dalmia Cement case, Air India case, Raman Services case, Consumer Educational and Research Center case, and lastly Keshwanand Bharti case. In my conclusion, I have recommended something that we cannot deny the effect of globalization. At the same time, globalization we will not accept. That is also not at all possible. So how we will harmonize these two concept of globalization and social security, that is the optimum question. The role of state is very, very vital one in this respect, and the role of civic society, that is also very, very important one. So that there must be a holistic development in this respect, where globalization and social justice, they will go hand by hand, where ultimately we can perceive the thing according to the words of Gurudev Rabindranath Tagore. পশ্চিমাদি খুলিয়াছে দ্বার, সেটা হতে সবে আনে উপহার, দিবে আর নিবে মিলাবে মিলিবে, যাবে না ফিরে, এই ভারতের মহামানবের সাগর তীরে। Thank you very much.
It's a very nice presentation. Sir has a question, one of the cardinal question of the globalization and privatization, and that is the de-investment and deregulation. These are the questions that we are now facing. Very nice presentation. Thank you.
Question? No question, so I would like to call up our next presenter, that is Assistant Professor of Law, IAS Gujarat, Professor Abbas. Professor, please.
Strategic leveling of conflicts, terrorism in Kashmir, and insurgency in Manipur in the context of armed conflict and human rights violations in a globalized era. A very good afternoon to all the dignitaries present here today, all my seniors and my dear colleagues. Today, I will be presenting my paper on strategic leveling of conflicts, focusing on how the term terrorism in Kashmir and insurgency or ethnic violences in Manipur are used and how these levels influence the state policy, international perception, and human rights outcome in a globalized world. The core concern of my paper is that conflict is not only fought with weapons, but also with languages. And this language has very powerful consequences. The strategic leveling of armed conflict in India, specifically categorizing the situation in Jammu and Kashmir as terrorism and the conflict in Manipur as insurgency or any ethnic violence, is a critical tool used to determine the state responses and allocate the military resources and shape the international perception in the globalized era. While both the religions, while both regions experience severe human rights violations, the leveling
Okay,
creates.
sorry, can you specifically mention how you can define the strategic leveling in that aspect? What are the strategic leveling you are asking for?
So can I continue with the paper and then yes. So while both regions experience severe human rights violation, the leveling creates a hierarchy of concern, with Kashmir often attracting more intense, unified, and securized national response compared to localized approach that is adopted for Manipur. Now in India, which officially classifies the conflict in Jammu and Kashmir as a cross-boundary terrorism, sponsored with some external actors. The labeling also allows for the invocation of stringent security laws such as UAPA and Armed Force Special Power Act, justifying the extensive military presence. In Manipur, insurgency and ethnic conflict with numerous terrorist groups operate in Manipur, and recent conflicts have been framed as an ethnic violence between the communities. Independent reporters have suggested that the counter-terrorism effects have resulted in extrajudicial killing, arbitrary detention of human rights defense. The conflict since May 2023 has resulted in over 260 deaths and 60,000 displacement. Reports have also included gender-biased violences, destruction of villages, and total blackouts in Manipur. Human rights watchdogs have accused state authorities of failing to intervene with UN experts flagging inadequate humanitarian responses. In modern international relations, terms like terrorism, insurgency, and resistance are not neutral. They shape how conflicts are understood, how governments respond, and how the international communities react. Calling this difference is clearly visible in this case where two regions with proper conflicts are very differently narrated. I would like to conclude that in both the regions, the prolonged use of armed force has led to normalization of a very brute power and an erosion of accountability. With AFSPA protecting security personnel from prosecution in cases of alleged abuse. The distinction between terrorism in Kashmir and insurgency or ethnic violence in Manipur is a strategic term
that affects how the state prioritizes resources and justifies its action, often at the cost of addressing the human rights of the local population.
Okay, very nice presentation. Any audience, any questions? Okay, thank you. You can call next question.
Thank you, ma'am. Now I would like to ask is Varshika Datta, student of North University. Please.
Good afternoon, everyone. I'm Varshika Datta, currently pursuing my master's at the University of North Bengal. Good afternoon, everyone. I'm Varshika Datta, currently pursuing my master's at the University of North Bengal. Today, my presentation is artificial intelligence and transnational cybercrime challenges to the human rights in connected world. In a globalized world, our rights is not only limited to the physical boundaries. In a world where we can gather information and share information just by one click, it is very important to ensure that our rights, human rights, particularly human rights for this matter, is protected not only in not only in our real world but also in the virtual world too. The quick growth of the AI and cyberspace blurs out the line between the real world and the digital world. In my paper, we examine how human rights are violated not only in the real world but also within the um, metaverse. Okay. So for this matter, I'm going to basically first discuss about the basic ideas, then we are going to discuss about the legal frameworks, and lastly we are going to discuss about the gaps and the guidelines according to me. Okay, firstly, we are going to discuss about what is human right. We all know that human rights are the basic right that belongs to everyone just because they are as human being. This is a basic definition of the human rights. However, in the digital world, in the fourth generation of globalization, the definition of the human rights is not only limited to the physical world. It extends beyond the physical boundaries. And secondly, when we talk about AI and in technology, AI is basically a system which functions like our human brain, but in more fast and more fast way. If that makes sense. For this matter, we are going to discuss about the legal frameworks first. For my paper, I am going to classify the legal frameworks into three classes. That is in international level, national level, and soft laws or the regional laws. In the international level, we all know the Universal Declaration of Human Rights. I don't need to discuss about it in detail. We don't have much time. So Universal Declaration of Duty is the basic framework for the human rights. It is not binding, it is laid out the framework for the international level. India is also a member, and even though it's not binding, it influences many countries' constitution, including India. Second, in the international level, we have Budapest Convention, which is the first ever convention related to the cybercrime that occurs in the cyberspace. So, in the international level, we mainly have these tools. Secondly, we in the national level, if we discuss, obviously we have our constitution, but for this matter, we are particularly going to discuss about Article 19 and 21. Article 19, freedom of speech and expression, and Article 21, that we try to dignity privacy. Article 19, freedom of speech and expression in the digital world, we are expressing ourselves not only in the real world but also in the digital world. So in the digital world, we express our media through social media, through journals or whatever, through Facebook and all. So in that case, you may ask how these are violating our freedom of speech and expression. So in globalized era, government increasingly monitor our communication, our calls, our messages, whatever we are posting in social media. Despite of the assurance that our messages are encrypted, we all know the truth. Privacy is a globalized era. Secondly, we have, I can't discuss in detail because we don't have time. Secondly, we have Article 19, Article 21, that is, for this matter, we will try to privacy and dignity. So, like Article 19, the over sentence of the government violates our right to privacy because our communication, whatever we are posting, also in last week, we were talking about the CCTV usage and all. These are the
rights are fundamental right. There is nothing like privacy in real world, neither in real world nor in the digital world. And also the right to dignity. When we talk about dignity, first thing that strikes our mind is deepfake videos. In nowadays, AI is used to convert our photos, videos into deepfake videos. In that case,
Please put in a nutshell.
okay, so lastly, we have the soft laws. It's very important. Soft laws in the soft laws matter, we have UNESCO ethical recommendation. It's adopted in 2021. He is not a member of it. Secondly, we have UNESCO and also OECD principles of artificial intelligence. Also, India is not a member of it. And for this matter, United Nations also have CBPBU or the General Protection Regulation. So this is basically protect the data of the citizens, but also India is not a member of it. Lastly, there is ongoing project known as CNR, that stakeholders informed ethical for new technology with a high social economy and human rights impact. It's a huge work, so it's a big project of European Union. India is still not a member of it. So my conclusion here is there is a lack legal framework, and also we have Information Technology Act, which is outdated. The crime related to AI and new growing crimes like Bitcoin and identity theft, these are not the laws we have are very few to deal with these matters. Also, I think we need our own infrastructure. We need to develop our own individual app and platform to ensure digital self-reliance and safeguard our data. Thank you. Anyone have any question?
Thank you for presenting the paper. Audience, any question? Okay, we can call the next. Anyone? This is the last presentation.
This is the end of session 2 panel session. I would like to Rakesh, one assistant professor in the Department of Law from University, to address the gathering.
Thank you. Various papers here. All of the presentation is very good, and I appreciate your effort, your study, your approach here. And some of the papers that I have to mention about, like the Ms. Susmita Halda, one of our colleagues, has presented very nicely about the human rights concern of the other state and historical perspectives of the human rights study. And in a, she has mentioned the regionalism. So in some states, we have seen that the state, they do not follow the law themselves, typically the first world country, but they impose the human rights or the environmental law of the other country forcefully. That has been beautifully mentioned, and that we can call the hypocrisy of the first world countries. That has been mentioned by Sukhrita. Thank you. And next, some of the paper I have gone through, that is, I have gone through all the paper, like the digital globalization and human rights paper presented by Rachana. It was very nice presentation also, and I think in this all presentation, the very good presentation and the visual visualization was very nice. Dr. Saurabh Taluk have presented a very nice presentation, and that was the right rethinking of human rights in post-human era. That is one of the best paper I think in this area discussion. And another paper that okay, Thomas has also made a very good presentation, and he has mentioned some cardinal questions, right? Globalization, how affected the entire world, the sovereignty of the state. Like we have seen the de-investment, these are the happening, and the deregulation of the state-owned entities and privatization. That is one of the most important area of the globalization he has mentioned. And some of the paper like Ms. Vishnu has mentioned terrorism in Kashmir and Manipur. And these are all the good papers. But some of the papers, some of the presenters, the past presentation, they have many seminars, so they need to improve. And I would like to say that the new presenter, we have the Varshita, that 11 student. So I would like to say some words to all of you, especially the new presenter, that you try to mention, try to focus on your research question, or what is your main problem of the research that you would like to present. Because if you present the law existing, that all of us will know the law what is the lacuna, what is the specific area you are thinking for the reform, or there is any lacuna you are finding out. So first you try to find out the research area, research gap. That is most important. Then you design your paper, and you must have a conclusion of some findings. So that should be the content of the paper. Whatever the topic may be, try to mention your findings. What is your takeaway from the study? That should be mentioned in a paper, so that in further in later stage you can develop your paper. When we have started our journey as a teacher, as a presenter, we have started like this. So I would suggest you and hope that next time you will be present better. So thank you very much. It is also for me as well. I have learned so many things from you, and I have taken the note as well. So as I do every seminar, I take something new, and it is the learning experience for me also. And as you know, this is my first job also here. I have started from another private finance, but this is the first time I have joined here in 2017. So it is one of my now. It is my second home now, and my second home. So it is my pleasure. And thank you to the coordinator, Dr. Swatrupa Ghosh, for calling me here, and also the faculty member, Abhinav sir, and all other dignitaries and organizing committee. I have chosen paper as the best paper, and also chosen another paper as a best presenter. Okay, so I'll mention it to the coordinator, and coordinator will later on discuss. Okay, so that is confidential. So I think you will wait for that, and it will be a pleasure to discuss about that round. Thank you very much. Thank you for following your visit.
With that, now we come to the end of today's presentation. We will now have a brief reporting session to summarize the key takeaways from today's deliberations. The rapporteurs, please come forward.
A very good evening to everyone present here. I am Aruna Shortkar, the rapporteur of Technical Section 1, Panel Session 1 and 2. So without further delay, I would like to briefly present the report. Our first speaker, Dr. Rakesh Mandal sir, his title is Challenges Created by Globalization under the Concept of State in Article 12 of the Constitution of India. He discussed how globalization has blurred the boundary between public and private entities. He also raised some serious issues like lack of uniform judicial standard. He explained that private organizations increasingly perform public functions, raising constitutional concern regarding accountability. The paper suggested adopting a functional interpretation of state under Article 12 to ensure that fundamental rights are effectively enforced. He also gives some suggestions like robust judicial interpretation and also properly address all the areas. Our next second speaker, Surashi Manohar ma'am, her title is Death and Distribution of Indian Globalization in Modern Era. She highlighted both the advantages and challenges of digital globalization. She pointed out such as digital divide, inequality, and algorithmic discrimination, which disproportionately affect marginalized communities. Her paper emphasized the importance of inclusive digital policies and global cooperation to ensure equitable access and protection of human rights. He also gave some suggestions like the government should work on grassroots level and also work at the rural areas. Our next speaker, Srika Dashman, his title is Under Threat in the Digital Era, a human rights perspective. She focused on the growing threat to privacy due to technological advancement, such as surveillance, artificial intelligence, and large-scale data collection, referring to constitutional and interpretational protection. She emphasized that privacy is a fundamental human right, yet increasingly vulnerable. The paper called for stronger legal safeguards, data protection laws, and regulatory oversight. Our next speaker, Dr. Bonalisa Sakamak. Her title is in Wildlife and Globalized World, a legal critique of food management in India. She emphasized the relationship between globalizations and wildlife protection. She highlighted that despite existing legal framework, wildlife is often controlled to serve human interests such as exhibitions and commercialization. She questioned the legitimacy of private wildlife facilities and argued that wildlife possess a inherent right to exist, emphasizing the need for stronger and more stringent legal regulations. Our fifth speaker, Mohan Mukherjee sir, his title is Preconception and Prenatal Diagnostic Techniques and Gender Discrimination and Legal Law. He discussed the preconception and prenatal diagnostic techniques act and its role in preventive female suicide. While acknowledging its importance, he pointed out serious gaps in implementation and enforcement, particularly at regional level. The paper emphasized the need for improvement monitoring mechanism and stronger administrative accountability. And he also gave some suggestions like there must be more factory to raise awareness. Our next speaker is Yurika Span, and title is Globalization, Invisible eco-feminist framework for protecting indigenous women from violations in the era of global governance. She has presented an eco-feminist analysis of globalization focusing on the impact of extractive industries on indigenous women. She highlighted how these women face multiple layers of harm, environmental, cultural, and social. The paper proposed recognizing gender extractive harm as a distinct legal category and ensuring greater protection through global legal. Our last speaker, Dr. Chairman Officer, his title is a legal approach on digital violence against women at their workplace under the global perspective vis-a-vis India's standards. He has addressed the issue of sexual harassment at workplace as a serious violation of women's fundamental rights. He emphasized that dispute legal position, societal attitude, and enforcement gaps contribute to hinder progress. He also raised some issue like lack of awareness and gave some strong suggestions like stronger implementation, awareness, and distributional mechanism to ensure a safe working environment for the women. And also there should be a confidential reporting system. Thank you.
Very good afternoon. My name is Dr. Ruchi, a rapporteur of legal section 2 and parallel section 1. And the first speaker is Ms. Assistant Professor of Law.
topics titled How Globalized Lives Lead Research to the Part World in the Area of Globalization. She highlights how human rights discourse is often by the different ideologies and dominated by the powerful nation. She also explains how developing countries make a crucial role in shaping international human rights norms. And her paper critically examines and analyzes the relevance of third world approach to human rights in the contemporary global order. She also discussed about the most essential effect of third world approach and found on the adoption of UN Declaration of Rights and Duties of States 1949, the Charter of Economic Rights and Duties of States 1974, and the 1986 Declaration of Rights. And the second speaker is Rachna Bhatt, Assistant Professor of Law, and her topic is globalization and human rights, mitigating the promise and repetition of hyper-connected world. She describes about the impact of rapid digital growth on human rights. She also highlights that how digital globalization has improved access to education, healthcare, and opportunities, especially for marginalized groups. And she also suggested that about the need for strong legal framework and multi-stakeholder approach involving government to ensure the digital development has to be fair, inclusive, and protective of human rights. The third speaker is Dr. Shogoto Kalukar, and his topic is Rethinking Human Rights in the Post-Human Era, a Generational Discourse. And he talks about the human rights must adapt to the contemporary global challenges and remain inclusive, dynamic, and responsive to new developments. He highlights the issues. Those issues are whether the focus on the interaction of science, technology, and the law is a key aspect of post-humanism, and will future legal frameworks focus on the protecting rights in response to specific circumstances. And the last question is how far is the generational study of human rights in addressing post-human rights? He concludes his paper by those questions. The next speaker, Anju Manada Thakur, she and her theme is armed conflict and human rights in globalized era, human rights violations in armed conflict in the era of globalization. And she highlights how armed conflict remains one of the most serious threats to the protection and realization of human rights in the contemporary globalized era. She emphasized that civilians are the most affected in such conflict, facing such serious challenges. She also discussed about the role of UDHR and the Rome Statute of International Criminal Court in protecting to the human rights and ensuring accountability. And the next speaker, Dr. Tanmay Sheikh, and his topic is globalization, vis-a-vis social justice, opportunities or challenges in India. He said that globalization is a concept that affects many things all over the globe. The entire world is now a small village due to globalization. Like many things, the concept of social justice is also affected by the globalization. He highlights how globalization affects many things in all over the world. We cannot deny the effect of globalization, but we have to harmonize the globalization as well as social security, and we have to focus on the role of state and social security to play a role in making the effect of globalization worldwide. The next speaker is Upashana Vishnu, and her topic is strategic leveling of conflict, terrorism in Kashmir and insurgency in Manipur in the context of armed conflict and the human rights violations in the globalized era. She talks about the human rights violation which affect the state of Kashmir and the terrorism of Kashmir and insurgency in Manipur in the context of armed conflict make a bad effect on the human rights violation in the globalized state. And the last speaker for this session is Varshika Datta, and her topic is artificial intelligence and transnational cybercrime challenges to human rights in a connected world. She discussed about the serious challenges for law enforcement and the building of legal accountability in a globally connected digital space. As a result, fundamental rights like privacy, security, and freedom of expression are increasingly at risk. These levels of law, these levels affects the international law and affects the international law and refer to armed conflict. And we also discussed about the legal challenges which are related to the digital space global. Thank you.
Now, I would like to call Dr. Shubhapa, who is the convener of this seminar, to address this topic.
So we are at the end of 2 day, first day of the national seminar. So I just want to thank all of you and congratulate all of you for your beautiful presentations. I want to thank Dr. for come all along and join us. Thank you, Dr. Rakesh Mandal sir. He is not sir to me. He is like my brother and he knows my heart. I remember Okay, so one important announcement which I missed in the inaugural session, that we will choose for 2 days and for next day also for 2 days, and we will select 2 presentations, one from the academicians and another from the students. 2 categories are there: this presentation and this paper. So we will select 2 categories from the academicians and 2 from the students. So at the end of the 2 days, all the presentations, we will announce the names. Okay. Thank you all of you, and hope to see you in the next week. Thank you.
What a wonderful first day it has been. The presentations, the discussions today has given us so much to think about and reflect upon. We sincerely thank to our speakers, participants for their valuable contributions today. Your engagement and energy have made this a truly enriching experience. We look forward to see you all again tomorrow for the day 2 of this national seminar. We have another exciting day of presentations and discussions lined up, and we will conclude with the candidate session tomorrow. Thank you everyone, and have a wonderful evening. We will see you back at early morning tomorrow. Thank you.